Yeah, I'm gonna have to get in. Probably like right now. So it's kind of in the floor right in front of it. I'll give you a call tomorrow and kind of give you help because something might change today. But once they kind of procedurally figure out that it's basically they don't want to get the judge rules on it. And then once the judge rules on it,
I'll try and elaborate.
Took them a while to figure that rhythm out, but once they figured it out, then it was relatively simple. Yeah, you still have to pay like attention because as they get more casual, they're kind of like trying to get in there.
Couldn't tell if you'd been here or if you'd been in the water.
I'm gonna go splash some. All right. Well, I'll see you. Good break. Good to see you back, maybe.
Okay. So, I don't need to bring out the camera yet. You got this? What is it? I am the ones that see upstanding. I'm like, nah. We get what we get. I'm not fall like that. See you. 750. It's best camera I've ever had. Yeah, making it. They're gymnastic. Yeah, because they're like the same. You know, that's kind of nice. Running gun music. Yeah. Come on, I gotta change lenses. One lens, there's 600. Background. I can totally soften it. I can't like, make it look like an impressionist painting, but I can soften it. But it's great in low light, and the wireless is spectacular. They're just all blues, and they can't wait to get rid of it. Yeah. And okay, we're going to shoot somebody on the podium in the back of the convention center. Yeah, and this is like no problem.
Yeah.
I got great photos of like 4-year-old kids with the camera on their shoulder. Holding it, but it's on their shoulder. That's the plan, but there's some talk of sending me a quarter home. I wonder if I need to get above everybody's heads. What else is going on?
That guy with a GoPro was sticking a GoPro on it.
It's an efficient work.
I love small airports.
Yeah.
It's not like, there's no like rental car shuttle. It's like, oh, I can see my car from the edge.
Yeah. You basically walk off the plane.
Before your flight, get on the ground.
Yeah. I know. Miami.
Miami's terrible, Atlanta is awful. He's so good at all of this. I'm out of Denver, so I got to deal with it. Literally, I've been in Denver 13 years now. The airport's been under construction the entire time. Something's always screwed up. So it's got 3 terminals. It's got an underground train. And you can't walk between the terminals. So if the train's not running, you're just screwed. Just screwed. Yeah. You can walk the terminal.
Oh, and then
Wait till they get it running. Sorry, let's get on your plane.
This will take the quarter mile.
That is at least there's moving sidewalks.
If you're going to be
For a while there,
this life skill cars
just a
side.
And then I went to Avis. And Avis is the last car agency down.
So you're going to...
So get put my bags, go across, and go down, all the way to the end. And then like, oh yeah, you're in like A32, so the last row, and all the way. And I'm just really pushing all my gear. In the old days, you get a Skycap with curbside for you. It's just a
I've only done
run a little more quiet this time. Well, I had you to run with. It's funny, I saw it and I said I was driving by me yesterday.
That's the Secret Service. That was like yesterday.
No. I've been saying ribbon a lot from ribbon. Just like just like when I'm headed home, I'll just text Chris from ribbon. It's my thing. I don't want to be. I don't know. Like, I don't remember having dates when I was like, I remember some like funny like vibes, but we weren't saying it. Yeah, and they were like consistent because they didn't change every year. Like the comfortability, like it's not cool anymore. Like the 6
They kept doing this. I'm like, I'm gonna joke. There's like a lead just trying to.
I'm like, that was funny for like a day. It wasn't even funny to me, but I'm like, depends now.
my beer because them and there, like, I'm really close to
Yes.
trying to get their response based on what get the influence. And then that's like a pattern.
I think today I was just like, that's exactly what I did. Probably accurate.
And the huge data well is really interesting in this season of trials. It's to establish, which is interesting. I can see how they do it in the era to publish those things.
They seem happy. Oh, I didn't make them in the chat. But you know when you get it actually.
Yeah. I'm always like, I have to wait and help you take the shit out of that.
Who is this?
I think that might be Erica.
Oh, really?
Yeah. Because her assistant's on back then. Right, that was a short one in the ball down.
Oh, that's good.
Yeah, she just walked across the park.
Well, and that's turning point security. These guys, so.
Yeah, and
Hell yeah. All right.
yeah, I think that. Oh, yeah. Bringing down Peter's dog.
I ain't seen this kind of attention since
Bringing in.
when OJ was getting out of prison. Yeah. They left though.
Well, it's still quarter to 9.
Is it?
Yep. I don't blame him.
I guess Robinson's parents went in the back a few minutes ago.
In the back.
Yeah, they entered through where Eric
Oh.
came in yesterday.
Oh, I guess so. What? Yeah, I didn't see it. I was figuring that was like, well, when they Charlie's parents, it's like the other couple.
Yeah.
Sent this up.
For maintenance.
They don't know what your face.
Because I know that would do really well for I think it's one of the best videos for freelance and Jake.
Okay.
It helps that he retweets it, right? But people are happy. So basically, Brandon broke it down to me. So just take videos of calling in how that are affiliated and non-affiliated because it gives people to see. It's easy. I get Jack to throw thumbs up, or I'll do this, I'll do that. Like that's as much as I dislike Brandon. Brandon's taking video. He's really good. He got over 1,000 likes yesterday. Don Jr. leaving. I think he's the best.
Oh, I saw that one where you got Brandon leaving for lunch.
Yeah, that one did really good.
Yeah. I mean, that's basically all we can do. Aside from like, I haven't seen anybody like walking up and saying.
I'm surprised actually. I'm surprised
Me too.
people haven't been asking for comment.
Me too.
I think it's because it's Utah. It's like it's a lot more civil in the proceedings, but
Right.
it's like do this trial. It's like any other state. Ambush would be.
Yeah. Well,
I was considering
especially-
asking all his comments for but in a very
Yeah.
polite way. Do you have anything to say to the world? I hope you're doing well. You know, just be kind to them.
Yeah.
Yeah. Just nothing. Just do that. You know. So,
Yeah.
okay. Have a good day, man. Like,
Yeah.
okay. Now, Robinson's parents walking back.
Yeah, but somebody just got a text saying that Erica came in back.
know why they got that text, but I just wanted to see if that's the case.
They might have. I don't know. We
She did yesterday.
Yeah. Just work today.
No, Charlie's parents just came in like 5 minutes ago.
That was my first thought. And I was like, wow, this could be a fox.
See, that's how you know. You got fox that's gonna slow down. Yeah. Oh, right. I got you.
I was like, that's the one thing I don't really get on video. How funny it is. Water in the pipe. I feel like she's in this, isn't she?
Cattle playing. Yes. That's what I was saying too. That's what I did.
When you look at the disc, when we look at his car, all of that.
Right. Yeah, if you're
Gaming
like
Discords, all of that.
gamers, furries, probably some weird drugs, like, and being on the spectrum, like,
It's an FBI like dream.
yeah.
Like,
Yeah, something told me not to. And then, yeah, after that, it's a low threshold to entertain killing people.
I really don't even think people would be mad at Candace. If she obviously she's just clearly being dishonest about everything and profiting intentionally. Like if she just posed the question of wanting more transparency from the FBI, nobody would disagree with her. Like there wouldn't be, she wouldn't have created such a violent. Like
Yeah,
I
yeah.
think I know Jack. I was saying he doesn't trust the FBI. Nobody trusts the fucking FBI.
Tucker brought it up.
Yeah.
Did you see that one with him and Bruce Willis?
Yeah. Yeah.
But then he was just like, well, yeah, the FBI needs to do the damn job.
Yeah. He was like, granted, I think the evidence probably more transparent than ever. At least they're trying to.
Yeah.
And failing,
Yeah.
granted, but there's only so much they can disclose. I think it's
California, you don't need go wherever you want in California. You die. Right. So yeah, we do wildland fire, but for the most part we use water. Right. So if I have to deal line, it's a bad day.
yeah.
I'm happy to show up with a brush truck and put water on something. Yeah. Yeah. First you hike straight uphill, and then you high-speed garden. And oh, by at any moment you might have to run for your life. And yeah,
And make sure you have your pack on, because if you don't have that on, the fire will. I remember doing it halfway through the guy was like, anything. So I had to line them up. I'm just going to get over this.
I agree. Everybody needs to be here, should be here.
And I gotta.
I'm Ken. Nice to meet you. You here all week?
Just till Wednesday.
They did tell us, like, after we got here. Oh, we might send you to the fire. Oh, they could have brought the fire, but, like, again, not that you really need it, because they're not going to let you get close to you.
Yeah. I wanted you to refresh you were there 2 months ago. You probably got good video.
Oh, I didn't.
What's it called?
Oh, I actually used to, but that's just
So, yeah, CNN gets spoiled. Like, you know, California, the reporters are standing right next to the flames.
Yeah.
And then, like, you know, get to Arizona, like, where's the fire? It's like 10 miles that way. They can shut the roads. We can't get anywhere.
Fire last year. The fire was at least the majority. Here in
How's the fire in Tahoe? And on the California side, go where you want, do what you want. As soon as you cross the border into that, like, nope. Nice meeting you.
still waiting for more arrival.
Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Good morning, Judge.
Good morning, Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices. All right, is it the audio working?
Sorry, Judge, the WebEx audio is not working.
All right, well, let's just take a brief moment. And just let me know when it appears to be working. While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to. Is it working? Can you send them a link to where this is being streamed so they have something to look at? I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. All right. Today's, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order or with the court's instructions?
No.
All right. Well, thank you. I appreciate your cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right, and just as a reminder, the microphones at counsel table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in, and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect, thank you. All right, as of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, you're a witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit? Yes. And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or running of a summary of videos from UVU campus security footage that was obtained.
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that. Thank you. Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus?
It does, yes.
On September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
Okay. And in its entirety?
Yes.
And he actually, and then you collected an 1102 statement from him?
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I ask that it be scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would
Have
like me to-
you, I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, well, you review the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning.
And who did you review that exhibit with?
With Kimberly Durfler.
Okay. Was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Okay. Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
Thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, to be published in the courtroom and captured by the media. So, Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I defer on that very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. You know, if it's being published in a public proceeding in the courtroom, it should not also be it should not also be allowed to be published to the media. So,
thank you.
Thank you.
Mr. Sturgill, do you wish to respond or perhaps give a little bit more detail on what this video purports to show?
Well, do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back. Let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describe in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just wanted to clarify that. Ms. Nestor, given that additional information and anything further from defense.
Your Honor, Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the Rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. It's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, controls here as to whether in this public proceeding it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
From the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that clarification as it is guiding for this court and making its ruling. I turn to Utah. Well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records. Public court records include but are not limited to, and I'm going to go down to 2J, exhibits. But the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature. And those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. And we can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same, attempt that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what, you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you? Were you able to refresh your memory as far as the time?
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive, as you can see on the video here. There is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
Right. So right now, if you were to break this picture into quadrants, where would he be?
He'd be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15.
On what day?
On September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes, 2025.
So we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching...
Campus Drive.
And again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
Okay. What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
Okay. And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
Okay, and do you know who that officer is?
Officer Goforth.
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
On September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, during the early morning hours of the 11th?
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that that vehicle, or a vehicle matching the description of that, was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay, and who did he tell you that it belonged to?
Said there were 2 registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Okay. Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And this is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
all right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself, as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred.
Excuse me. Is anything other than faces being blurred?
Not that I recall, no.
Okay. And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. Mm-hmm. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video?
No.
The accuracy of the video in your mind?
No.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted into evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4 words, unless you want to share that with me.
I can read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may, let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision, or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom?
Yes.
Can I make one suggestion, Judge, or maybe one request? I believe the most important part, the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video, if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way, rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you, I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitors at counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing the constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary, or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
Sure, if I could just have one moment. Hold on, Kimberly. Not sure where the power button is on this. There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom, and you may present 12.1, the portion you wish for me to view. And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, at 8:23, okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hull, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing? strike that.
Mr. Sturgill, do you want to respond to the
Yeah,
objection?
Judge, it is leading.
All right, I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
Just one moment, Your Honor, if
Of
I may have
course.
the court's indulgence. Thank you. Do you want to take your?
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess. We'll go ahead and pick up where we left off. I note that the parties for each side are present in the courtroom, and we are picking up with cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court, thank you. Good afternoon, Agent Hall.
Good
You
morning.
and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved?
not, no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I wasn't. I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area?
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured, and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
That's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were ultimately, they were all ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the low-C roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the low-C building?
When you say around the low-C building, you mean how close? Like immediately around the low-C building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
It looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was, or
No,
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the...
Correct.
From the parking garage.
Correct.
But the video on the roof was not distinguishable, fair?
That video as a standalone?
Yes.
Was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event, a video that they had taken of someone on the roof about 10 seconds before the shooting.
Yes, a video, yes, not photographs. A video was collected from an individual who had a video.
And ultimately, some screenshots were taken out of that video, is that right?
By
you?
Not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event.
Okay.
If that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct.
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct.
And is this the moment where you are submitting that he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone.
Right.
I think it took longer for him to crawl into position.
Okay.
And then establish a position,
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay, thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct.
And it showed like a dead-on view of Mr. Kirk and parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not.
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nifster, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was
boxing it, shipping it, sending it wherever it was going to go to be analyzed?
I was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Ms. Noble?
Mhm.
Yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Ms. Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment. Let's see. Whole 48. This is Ms. Noble's interview. Do you have it? All right, do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. as you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon?
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they carrying?
I believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing, in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail
It
what
appears
that item might
it
be?
appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to say? Do you remember seeing the banner?
Yes.
In the video? Okay.
You're referring to the back of the pop-up tent?
Correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent?
No, you can't see through it. It's white,
Right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at, is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA, there are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the...
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
Okay. And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so...
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office?
Yes.
Okay. You understood that he turned him, well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. Oh, sorry. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the Low-C building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, There is no longer a visible limp or gate.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
We have just a minute to meet if,
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess. Session. We left off with Agent Hull was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just, do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102, because if the court looks at the last paragraph of this, Mr. Englehart, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection, because the court said no speaking objections? Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think, I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about? Or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here which is Mr. Englehart's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here, in this proceeding, what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks, and again, I say this with all due respect to Mr. Engelhardt, who I've never met, the book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve, with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the targeting enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes. Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying This is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say, constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kern's Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And that's been, we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kern's Tribune also speaks to this. And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kern's Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly Twilight Zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar, and I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right, thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement, in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for at the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see, but there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
Okay. All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it. You said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All rise.